Today on Law Weekly, Lagos State Judiciary visits Ikoyi prisons as part of activities to mark the 2016 legal year. The coordinator of the Lagos State Restorative Justice Steering Committee, Benson Iwagu, speaks to us on the spectrum of restorative justice as an optional pretrial diversion. And later, lawyers speak on the suspension of the former chairman of the House Committee on Appropriation, Abdulmumim Jubrin. Thank you for joining us. I'm Victoria Ido. Let's get to it. We start at the Ikoyi prisons, where the Chief Judge of Lagos State has released 20 awaiting trial inmates. She says this is part of a move to decongest the Nigerian prisons across the country.
The Chief Judge of Lagos State has released 20 awaiting trial inmates from the Ikoyi prisons. She says that this is part of the move to decongest the Nigerian prison across the country. 50-year-old Thompson Henry, who was a sector commander with the Nigerian military, has been remanded at the Ikoyi prison for almost 2 years. He tells Channels Television that he was arrested when he returned from duties in the northeast, accused of deserting the war on insurgency. Today, he and 19 others get their freedom. The Chief Judge of Lagos State, Justice Olufunmilayo Atilade, granted them their freedom. The Chief Judge says everyone deserves a second chance to live a normal life.
Without prejudice to any further proceedings that may be brought against you at a later date. And I enjoin you to go and sin no more.
At the Ikoyi prisons, there are 2,358 inmates. 221 are convicted, while 2,037 are awaiting trial.
It is my belief that at the end of the inspection, these inmates will be satisfied that justice has been dispensed to them accordingly.
It's an opportunity for the prisoners to showcase what would have been hidden.
Do it the second time. Okay. It is not reviewed.
Section 1, subsection 1 of the Criminal Justice Release from Custody Act, Special Provisions 2012, gives the Chief Judge of Lagos the statutory power to carry out this obligation.
Lawyers and judges in Lagos State have been brainstorming at the Bar and Bench Forum, focusing on issues troubling the judicial sector. The event held at the Lagos Island Division of Lagos State High Court Igboshere as marking the commencement of the 2016 legal year.
Gathered here are members of the Bar and the Bench for an interactive session marking the start of the Lagos State 2016 legal year. The Chief Judge of Lagos State, Justice Olufunmilayo Atilade, says she looks forward to a new year where the state justice delivery system would be enhanced. But for that to happen, more judges need to be appointed. On the table for discussion among the lawyers and judges is the issue of plea bargaining and negotiation in criminal justice administration.
The use of the concept has been condemned by some legal practitioners and scholars, while some others have endorsed it as a welcome development in the Nigerian criminal justice administration. This is because, like any other concept, it has its advantages and disadvantages. Some of the more notable arguments against and in favor of plea bargaining are as follows. Arguments against: discriminatory and may cause injustice. The victims or people affected by the crime and the general public may sometimes be angered by the concept of a plea bargain, especially if they feel the crime deserves to be punished with the full extent of the law.
The Bar and Bench Forum is an opportunity for the Lagos State Judiciary to show the amount of work that has been done to improve the Lagos State Archives and Property Litigation Registry.
Statistics show that about 2.5 million Lagos residents suffer from one form of mental illness or another. This is the reason for this gathering, where stakeholders are discussing what the law must do to protect mentally ill individuals in the state.
People with mental health issues suffer stigmatization in many parts of the world, and Nigeria is no different. But that trend is about to change, at least in Lagos State, as legal practitioners Judges and medical personnel discuss the way forward. A look at the mental health law shows that the current law in Nigeria allows any building to house an asylum, and it contains no requirements for treatment of civil lunatics.
The protection of the human rights of people with mental disorders is an obligation of the state in the spirit of solidarity, beneficence, non-maleficence and justice.
A closer look at the legislation shows that Nigeria's mental health law is grossly inadequate and urgently needs a makeover.
Our law on mental health remains grossly inadequate, indeed hopeless to deal with the situation that obtains in Nigeria today, where, despite the estimate of the World Health Organization, WHO, that about 20% of Nigerians suffer mental illness, and this was much more before the current economic situation, the predominant number of persons with these illnesses are either oblivious of it, ignored, or stigmatized by society, or end up in the care of spiritual and medical quacks.
If discussions here are put into good use, the issues of stigmatization and abuse of mentally ill persons will be a thing of the past.